register with the Child Care Law Center for this training, or you can go ahead and visit the link that I've placed in the chat and complete the form there, just depending on what's most accessible to you. Thank you so much for joining today, and we'll go ahead and get started. With that being said, I'm going to move on to the next slide. So, welcome everyone. Today we'll be doing a brief 1-hour training on the immigrant rights in childcare settings in California. Just wanted to say a huge thank you to everyone for joining on during your lunch hour. I know this is going to be a heavier topic to talk about this afternoon, but I greatly appreciate your time and your interest in this topic. And a huge thank you to LAAC for co-hosting this presentation. My name is Gianni Interiano Brown. I use she, her pronouns, and I am a senior staff attorney with the Child Care Law Center. Before diving into today's information, I do want to just share a little bit about who we are at the Child Care Law Center. We have a mission to educate, advocate, and litigate to make childcare a civil right. And we are what's called a statewide legal support center that is specially funded by the California State Bar to support qualified legal services projects, or QLSP, legal organizations. As a legal support center, we do the following. We provide trainings, publications, legal technical assistance, and other resources to both legal aid attorneys and the general public, including childcare providers and programs, as well as California families. We also create just childcare policies, meaning we engage in legislative advocacy at the state and local levels. And we do focus solely on 3 areas of California childcare law. Those 3 areas include housing rights of home-based or family childcare providers in California, the California family's right to affordable publicly funded childcare, also known as a childcare subsidy, and the disability rights of children in childcare settings. And recently, we've been engaging in the immigrant rights of California childcare providers and families who have children in childcare. I do want to note that we have a disclaimer today that this information presented during today's training is just that, just general legal information and not legal advice. This training and accompanying materials are intended as a general overview and for informational purposes only. That being said, the Child Care Law Center is not your lawyer, and the law does change often. So for advice about any particular legal situation or individual legal question, we recommend you contact a lawyer. And this training and our materials do not create an attorney-client relationship. So here's an overview of what we'll be discussing today. And I do want to start off today's training with why it's so critical to learn more about this topic. So a significant part of California's population are children of immigrant families and have at least one immigrant parent. Additionally, a large part of the United States workforce are also immigrants. Considering the diversity of our communities, it is very important to understand immigrant rights in the United States, including immigrant rights in childcare settings. And as noted, this training will only focus on these rights in childcare settings or involving childcare programs. Over the next hour, this training will discuss the following: immigration enforcement and general immigrant rights in childcare programs, including home-based programs, programs in commercial settings like childcare centers, programs in school settings, and childcare programs that are held within public spaces. We'll also be talking a bit about preparing for and responding to law enforcement requests in childcare programs, steps to take after law enforcement interactions in childcare programs, and we'll end with some general questions from the audience. If you do have a question throughout this training, I urge you to put it in the chat. You can designate it to hosts or panelists and I'll receive it directly, or you can put it in the Q&A box as well, and I'll make sure to address it at the end. So starting us off, immigration enforcement and immigrant rights in childcare programs. And just in case folks are unfamiliar with different childcare settings throughout California, I wanted to start with this slide as a way to level set. So we have a variety of childcare settings in our state. Just to give you an idea of why we'll be talking about both, private and public spaces in the context of immigration enforcement and authority. So first we have what's called a family childcare home. This is a home-based licensed childcare facility in California. It's licensed by the state of California, and it's a much smaller childcare program setting that is operated outside of someone's own home. This home can be rented or owned by the childcare provider themselves. And a childcare provider in this type of childcare setting can care for up to 8 children with what's called a small family childcare license, or up to 14 children with what's called a large family childcare license. And because this type of childcare program is licensed by the state of California, just like other types of programs, they are heavily regulated and inspected by the state of California, specifically the California Department of Social Services Community Care Licensing Division. Next, we have a more probably commonly known childcare setting in California called a childcare center. This is also a type of licensed childcare facility in our state that is also heavily regulated and licensed by the state of California. And since it's a larger setting, typically operating out of a commercial space or a school-like setting, usually a childcare provider and a team of other childcare providers will be caring for more children in this type of setting than in a family childcare home. And finally, we just want to share there's another type of childcare program. It's called a family, friend, and neighbor care program, or someone who operates this is called an FFN provider. This is a license exempt type of childcare setting. A background check is required to receive payments from like a family paying with a childcare subsidy, with some exceptions. And typically, this is the smallest form of a childcare program where the childcare provider is typically caring for their own children as well as a child from another family. I do want to note that, like in the title of this type of program, the childcare provider is going to be a family member, a friend, or a neighbor. So that's why it can be a quite a small childcare setting, and it is unlicensed. So with that being said, childcare settings are varied in our state, and it's important to know now, like, what do these settings, what are they designated as in terms of immigration law and enforcement? So in 2011, the United States had a policy called the Sensitive Locations Policy, also known as the Protected Areas Policy. And this said that immigration enforcement, like ICE, could not enforce federal immigration laws in protected areas, like places where children gather, which included childcare programs, schools, playgrounds, and recreation centers. However, that all changed in January of 2025. This year, the Trump administration said that immigration enforcement could enforce federal immigration laws in previously designated protected areas as long as they used common sense, which was defined very ambiguously. These protected areas could absolutely now include childcare programs and other spaces where children gather, which is why today's training is so critical to really understand that now we might be seeing a lot more law enforcement, including federal law enforcement engagement in these spaces, in and around these spaces, excuse me. But of course, with that being said, childcare providers, children in care, and families with children in childcare still have rights. And this might just be a reminder for folks on the call who might not be engaging in immigration defense work, but we did just want to put up some examples of what federal immigration law enforcement looks like. With that note, I'm sure everyone on the call is very aware that these individuals have been seen wearing plain clothes and unmarked cars, but we just wanted to provide this for context. We have examples of different types of federal immigration enforcement agents. That doesn't just include ICE. It includes individuals working for the Department of Homeland Security or DHS, Federal Protective Services or FPS, as well as agents from Homeland Security Investigations, also known as HSI, and Customs and Border Patrol or CBP. Unfortunately, in different types of administrations, these agents kind of stay within their own jurisdictions, but in times of increased immigration enforcement, their areas of jurisdiction often overlap or get expanded. So we do tell the general population, general public, that you could really engage with any of these types of agents. Of course, if they're in plain clothes or in uniform, always a best practice to ask for their identification if ever approached by someone who may or may not be law enforcement. Now, with that being said, talking about California local and state law enforcement, this might be fully known by folks who engage in immigration legal work, but it's important to know that local police departments, sheriff's departments, and California Highway Patrol, or CHP, are local and state law enforcement agencies, offices that might be engaging with childcare programs as well for a variety of different reasons. However, that is going to be quite limited in terms of immigration enforcement. And that's because of the California Values Act, also known as Senate Bill 54, or California's sanctuary state law. So folks are probably aware, but this law has been in effect since 2017. And generally, this act says that local and state law enforcement cannot help with federal immigration enforcement, with very limited exceptions. So specifically, California local and state law enforcement cannot investigate, interrogate, detain, or arrest people for immigration enforcement purposes, including but not limited to asking for someone's immigration status, sharing someone's personal information, like their social security number and home or work addresses, unless that information is public. They cannot help arrest or continue with arresting someone based on civil immigration violations. They cannot help federal immigration enforcement at the border, and they cannot act like an immigration officer under certain agreements between their city and the federal government. So it's important to note that even with this law, California law enforcement can still investigate, detain, or arrest people for criminal activity under state or federal laws. And we do want to note that even though there's restrictions in ways that state and local law enforcement can collaborate with federal immigration enforcement agents, there are different ways that county law enforcement interpret that or want to proceed with that type of work. So we have been hearing and seeing certain counties absolutely collaborating with federal immigration enforcement. So it's important for advocates to know what's going on in their immediate area and to advise their clients and their communities accordingly. I do also want to note that this last legislative season in the California legislature did see the passage of a new law. I believe it's called Senate Bill 805. This law does require non-uniformed law enforcement officers to visibly display identification, including their agency and either a name or badge number while on duty. So even though we have been seeing and hearing officers in plain clothes or not identifying themselves, it's absolutely allowed and it's a right that people have to ask them to identify themselves. And hopefully we'll see enforcement of this law in the coming year. So now shifting gears to general immigrant rights in childcare settings. So no matter if someone is inside or outside a childcare program, when interacting with any law enforcement, state, local, or federal, people have the right to stay silent and not answer questions without a lawyer, the right to ask law enforcement agents or officers to identify themselves, the right to document and record interactions with law enforcement, of course, with the caveat if they feel safe enough to do so, the right to ask for a lawyer, of course, and the right to not consent to a search or seizure. Now, similar to, advice that attorneys give when engaging with law enforcement, receiving a request or a demand from law enforcement, we want to talk about valid judicial warrants for childcare settings. And we've been advising the community to know the difference between a valid judicial warrant and an immigration or administrative warrant. So, a valid judicial warrant is a written court order. It gives law enforcement the ability to enter a private space and search or seize. Note, law enforcement can enter public spaces without a valid judicial warrant, and we'll go into more detail on the differences between private and public spaces later on. So when I say that a valid judicial warrant is a written court order, that means it's issued by a court and signed by a state or federal judge, not an immigration judge. And once a law enforcement officer or agent presents a valid judicial warrant, they may arrest someone, take items like documents, or enter and search some private space like a home. And it's important to know, how does one know if they are being presented with a valid judicial warrant? We advise people or recommend, just based on best practices from our partners that we've had that engage in this work, to absolutely pause, ask to review the warrant themselves, not take what agents or officers say at face value, and look at what kind of court issued the warrant itself, or what official, like person, signed the warrant. So looking for examples, looking for details like, the Superior Court of California or U.S. District Court in terms of who issued the warrant. It's also really important to look at the home or business address on the warrant and the person mentioned in the actual warrant. If law enforcement is at the wrong address, or the person mentioned in the warrant is not actually present or has never been present at the location, law enforcement cannot use the warrant to enter, search, or seize. It's important to know that if this is a warrant saying that someone needs to be arrested, it's only valid at the home or workplace of that person that they're arresting. Lastly, it's important to check the date and signature on a warrant, because valid judicial warrants can only be used for 14 days after they are dated and signed. And it's a good reminder that when someone is given a valid judicial warrant by law enforcement, the law does say that that person has to obey the warrant or face legal consequences. That doesn't mean they just have to step aside and let them proceed with entering a private space or a space not open to the public. They can still document the interaction and follow law enforcement while they execute the warrant and make note of anything that they do, say, or see, or even take. So with that being said, I do want to note that an important exception to think about when thinking about childcare settings is the consent exception to having a valid judicial warrant. This can be an issue because if we're thinking about a childcare space, we're thinking about a lot of people in a childcare program setting. We're thinking about children, we're thinking about adults that may, be waiting for pickup and drop off. So parents and guardians, entering the childcare space, opening the door for adults to pick up children, or feeling compelled to let someone into a childcare program because they're an official with some sort of official documentation. So it's really important to note that the consent exception might come into play when law enforcement is trying to get into a childcare program. So as a reminder, the consent exception to this warrant requirement allows law enforcement to enter a space without a valid judicial warrant if someone gives them consent, verbally or in writing, saying that they can enter a private space, speak with someone, or take something without asking for a valid judicial warrant first. If that happens, if consent is given over, a door is opened without any further questioning to law enforcement, they may feel they can proceed without needing to present any other documentation, like a valid judicial warrant, which is why it's so important to pause, ask for the warrant, ask for identification, and not automatically agree to letting anyone, law enforcement, or someone posing as law enforcement, to come into the program. And another important reason that if you have clients or you work with folks who operate childcare programs or work with children or just generally have a increased fear of having law enforcement come to their home, to just ensure that everyone present in the space knows do not let unauthorized visitors, strangers, adults into the space. So now the difference between a valid judicial warrant and an immigration or administrative warrant. So these are also known as ICE warrants or warrants of removal, and they're a written document that allow federal immigration enforcement like ICE to arrest someone or seize or take something like documents in public areas. These types of warrants do not allow federal immigration agents to enter or search a private area. And unlike a valid judicial warrant, these types of administrative warrants are issued by a federal agency, like the U.S. Department of Homeland Security. Additionally, these types of warrants are not going to list a case number, but rather will list an A or an alien number. And they'll likely mention immigration or immigration law, like the Immigration and Nationality Act or the INA. And rather being signed by a federal or state judge, this is going to be signed by an immigration judge or an immigration officer, like an ICE agent. And we have been informed that, this isn't always something that happens. So you can look for a signature from an immigration judge or immigration officer, but these warrants may be presented unsigned. So when given this type of administrative warrant during an interaction with immigration agents, people do not have to allow these agents to enter or search a private place like a home or another non-public area. And if law enforcement tries to force their way into a home or business with this type of administrative warrant, people can absolutely respond by saying, "I do not consent." But of course, if this happens, people should take into consideration their own personal safety and not engage in stopping or physically restricting law enforcement from entering or searching the home or business. And of course, when you're presented with this type of warrant, people still have the right to remain silent. Next, I just want to note two different other types of documentation that people might receive when interacting with law enforcement in or around a child care program, and those are subpoenas. The first type of subpoena is a judicial subpoena, which is a written court order that requires someone to testify as a witness in an investigation or give over documents, papers, or other evidence. A judicial subpoena is issued by a court. It's signed by a clerk of the court or a judicial officer, and it is not signed by an immigration judge. A subpoena that is signed by an immigration judge is called an immigration subpoena, which I'll talk about in the next slide. So if law enforcement gives someone a judicial subpoena, they cannot ignore or resist the demands in that document. There are serious legal consequences like having to pay a fine, or in some rare or extreme cases, a person could face imprisonment for refusing to comply with a judicial subpoena. And it's important too that if folks have questions on whether or not they need to comply or how to respond to a judicial subpoena, they can seek legal counsel just to see if they can object in certain ways, especially when being required to produce documents or being required to testify. And that goes for judicial warrants and immigration warrants as well. You can absolutely contact an immigration lawyer or a criminal defense lawyer to see what your options are. Finally, what are immigration subpoenas? So this type of subpoena is also called an ICE subpoena, and it's a written document from a federal agency like the Department of Homeland Security or ICE, and it demands that someone testify as a witness in an investigation or give over documents, papers, or other evidence to federal immigration enforcement agents to then be used in immigration court. This type of warrant might be signed by an immigration judge or an immigration officer, like an ICE agent. And again, if an immigration officer from an agency like ICE or CBP gives someone an immigration subpoena, the officer cannot demand that the person obey the subpoena unless the officer also has a court order from a U.S. district court, not an immigration court, that specifically requires the person to obey the subpoena. There are legal consequences for refusing to comply with an immigration subpoena if the federal agency that issued it takes additional steps in U.S. District Court to enforce the subpoena. So, alone, an immigration subpoena does not have as much power as a judicial subpoena unless it's accompanied by a court order from a U.S. District Court. So next, I want to talk about preparing for law enforcement interactions with childcare programs. In a lot of these best practices, recommendations that we've gathered and developed with our legal partners do mirror a lot of other recommendations for similar spaces, just workspaces in general, but I did want to note them and a couple differences that we do share with childcare providers and programs. So, the number one best way, or maybe the first best step to consider when trying to prepare a childcare program for these increased heightened interactions, is choosing what we call an authorized contact person. So, an authorized contact person should obviously be a carefully chosen member of a childcare program who will primarily interact with law enforcement on behalf of the program. They must be available on site during childcare program hours, familiar with different types of warrants and subpoenas, and comfortable with checking the date, location, and scope of different types of warrants and subpoenas. They will, of course, have certain responsibilities. So before interacting with law enforcement, this person will be informing adults and children in the program about, the program's policies that will help prevent, accidentally opening doors to law enforcement, will help people understand their rights during an interaction, etc. And before interactions, this person will also be preparing themselves and other adults, other staff members in the childcare program for the potential for unlawful entries, searches, and attempts to arrest people in the childcare program, even after asserting immigration and other civil rights. Now, during the interaction, the authorized person will be primarily engaging with law enforcement, talking about the program's policy. For example, we have a policy of only allowing entry with a valid judicial warrant, and we'll be ensuring that the policy for the program is respected or at least somewhat enforced with law enforcement before, during, and after interactions. They will be, of course, asking for, reviewing, and documenting law enforcement credentials, IDs, and other information. They'll be asking for and reviewing any documentation law enforcement gives over, looking for whether they're presenting a valid judicial warrant, a judicial subpoena, etc. They'll be likely documenting the interaction in writing or on their phone, like videoing or recording audio if at all possible. And finally, this person will hopefully have access to a list or at least some contact information with an attorney or legal services organization to guide themselves and the childcare program during and after the interaction with law enforcement. So preparing a childcare program doesn't just end with preparing the authorized person. It also involves preparing any staff on site and informing families in a program. Of course, it's going to look different when you are taking care of maybe a smaller group of children. You maybe just have one assistant besides yourself as a childcare provider versus maybe a larger setting with multiple staff members and more than 30 families in a program. But all that to say, it is incredibly important for childcare programs, just like schools, K through 12 schools and colleges and universities, to create what's called a written safe spaces policy. This type of policy is really important to help train staff for unexpected and stressful situations, to help them understand and protect the families and the childcare program's legal rights. It helps staff, feel encouraged to discuss and come to an agreement on how everyone in a childcare program will react in these heightened situations. And it'll absolutely help the program communicate to their staff and to families with children in care that they are welcoming of immigrant workers and families within the program. Now, if a childcare provider is an employer, they should absolutely have employees' emergency contact information on file beforehand. And of course, with that being said, they should absolutely have families' emergency contact information updated and saved in files as soon as possible. So another thing to note about what can be documented within this written policy for a childcare program, it should be, when are we going to use this policy? And what interactions will fall under needing to use this policy? Who is that authorized person that'll engage with law enforcement on behalf of the program? What information on childcare program staff and families will be collected and protected in terms of privacy from any outside requests from people like law enforcement? How are we going to monitor and receive any visitors at the childcare program? What are the public versus private spaces in the actual childcare program facility? And specifically, what steps is the authorized person and also any adults, staff member on site going to take when law enforcement is in or around a childcare program? So, with that being said, all that information shared with staff and just kind of solidified within the program internally should be shared with families with children in childcare. It's really important they know exactly how a childcare program is going to protect their information and their children during these types of law enforcement interactions. If at all possible, it's really helpful to share resources on families' immigrant rights, sharing anything regarding family and child mental health support, and perhaps even a list of local immigration legal services that families can reach out to for more support. Ideally, childcare programs should be encouraging families to complete what's called an emergency family preparedness plan and creating and completing what's called a caregiver's authorization affidavit, which would allow another adult to temporarily take care of a parent's child when a parent is unable to do so. So now I want to talk a little bit about public versus private areas within the context of when law enforcement need a valid judicial warrant to enter and search. So public areas are seen as places open to the public, and law enforcement can enter and search these areas and can try to question people in these areas without presenting a valid judicial warrant first. So some examples of public areas usually include sidewalks, public libraries, parks, museums, beaches, theaters, and even privately owned spaces like restaurants that are opening themselves up to the public for business. Public areas in or involving a childcare program could include the following: a waiting room in a childcare program in a commercial building, like a childcare center, if that room is accessible to the public through an unlocked or open door. It could also be the public sidewalk that anyone can use in front of a childcare program. Could also be the front area of a parking lot of a public elementary school, college, or university that houses a childcare program that anyone can enter or wait in. Could definitely be the playground or park where a childcare provider takes children during program hours. And it could be a public space like a museum or library where a childcare program takes children on field trips. In contrast, private areas, like what is a private area, will depend on where someone and where the general public might have what's called a reasonable expectation of privacy. And that means that basically someone has an honest individual belief that the area they are in was more private than other areas. And in general, most people would also believe that that area was more private than other areas. A helpful way to visualize what reasonable expectation of privacy means is thinking about the common example of a public restroom with multiple bathroom stalls. Yes, this type of setting is open to the public to use. However, when someone is in one of the locked bathroom stalls, they likely have a personal, individual belief that that stall is more private than other areas of the bathroom. And in general, most people in our society would also agree that that locked bathroom stall is more private than other areas open to the public. So with that being said, what are some examples of private areas, private spaces in or involving childcare programs? Well, like I mentioned on the first slide, we do have a childcare setting in California that is home-based. So a private area involving a childcare program could be the private home where a family childcare provider lives and operates their childcare program. It could also be the office of a childcare center director or a childcare center administrator that is only open to childcare program workers and is not open to the public, families, or children in the program. And finally, the bathroom in a childcare program is likely a private area in that space. Next, it's important to note the plain view doctrine. Just like with any other spaces that might see increased law enforcement interactions, if law enforcement enters a childcare program without a valid judicial warrant, that could be because someone consents to letting them in or because that area itself is actually a public area. Law enforcement can look at and take anything in plain view or plain sight. So, for example, anything that's openly visible, anything on an unlocked desktop or computer screen, anything sitting in someone's trash can, any documentation that's at the top of a pile of papers, and any documentation that's believed to be related to, some illegal activity or the reason behind a law enforcement search. And I do want to mention one other exception to the valid judicial warrant requirement, and that's the exigent circumstances requirement. So law enforcement can enter a private space without a valid judicial warrant if there is some certain urgent or time-sensitive circumstances. However, this is a very narrow exception, and that is when it's used to, ensure that evidence is going to be obtained before it's about to be destroyed, to address a public safety issue, to be in hot pursuit of a suspect, or a suspect is likely to escape law enforcement, all before a valid judicial warrant can be obtained. So even under this rule, if law enforcement enters a private area without a valid judicial warrant, any related search must be limited to investigating an incident that created the urgent circumstance. Next, I want to go a little bit into the parameters around childcare programs having and sharing any information on children and families in the program. There's also a bit about the collection of staff member information as well. So California law limits what personal and sensitive information the California Department of Social Services and its contractors that administer publicly funded childcare can require from families and childcare programs. For example, federal law and guidance do not permit the Department of Social Services contractors to require childcare providers' Social Security numbers. California law and regulations also do not require the collection or maintenance of information concerning the immigration or U.S. citizenship status of a family or child in care. This information should only be available to program staff for programmatic or educational purposes. Families' information should not be disclosed to non-program officials, like federal immigration enforcement agents, without a valid judicial warrant, a judicial subpoena, or the parent or guardian's consent. Specifically concerning K through 12 schools, federal and state law protect students' educational records and personal information. These laws generally require that schools get written consent from parents or guardians before releasing student information, unless the release of information is for educational purposes, is already public, or is in response to a court order or judicial subpoena. Please note that the California Attorney General released guidance in December of last year for K through 12 schools and colleges and universities. So if you're working with someone who works or is sending their children to a childcare program on these types of school settings, you can find guidance on how those settings engage with law enforcement and save and, protect information on the AG's website. So it's important for childcare programs to know what personal and sensitive information they must collect and store, and what information they do not need to collect and store on themselves, their staff, and families with children in care. They must only request and store data needed and required for enrollment or educational purposes, and all stored data could be investigated by immigration enforcement, which is why it's important to narrow what kind of information needs to be collected and stored. Childcare programs can also collect needed information without requesting sensitive or personal information that might relate to a family's immigration status. And again, childcare programs are not required to collect or keep information on families' immigration or citizenship status. So as some best practices, it'll kind of depend on what a childcare program, where a childcare program stores their information. So for digital files, and for honestly any business, it's important to have encrypted and password protected files, dual factor authentication, and to limit access to files to only necessary staff members. For physical files, always important to keep those files in a safe location and protected with physical locks. So thinking about a filing cabinet that has a lock or code on it that only certain people can access. And of course, it's important to have all of this protocol policies written down and to create and train staff on the written policy. So telling staff, absolutely do not open any links, any emails from unfamiliar senders. Do not save any, any files from the business, the program, to their personal devices, and to not download any programs without the childcare program's consent. And this is just a reminder of some model policies and guidance from the AG's office, as well as two recent K through 12 related bills that passed in California this year. Okay, so just wanted to highlight, and I would like to leave time for questions in case folks have any, but I do want to highlight just a couple of reminders, depending on what type of childcare program we're talking about, in case you engage with any clients of different programs. So a good thing to note is a childcare program will have to take some additional steps in creating their safe spaces policy if they have a backyard or shared outdoor space. So we're talking about a gated backyard, an ungated front yard. Maybe they use a shared playground in their gated community, or they have a shared outdoor space in their apartment complex. So, depending on what type of outdoor space a childcare program might have access to, might use, they may have a different expectation of privacy under the law. So, regarding backyards and outdoor spaces, how private an outdoor space is can depend on other specific factors, like who else can actually access the outdoor space. So, it's not as intuitive as you think. So, childcare programs may consider certain best practices or policies while children are in their care and while they're using their program's outdoor space. So, for example, if a program has a gated backyard, really key to have a strict policy on who can enter this space from the outside, like a public sidewalk or the street, and important to keep that area locked, at least during the hours of operation. For ungated front yards, even those in gated communities that open to the public, sidewalk, or street, you might consider limiting time with children in that area, especially if law enforcement is reported to be seen in or around the community. So, for shared playgrounds or other shared outdoor spaces, especially those that are easily accessible by other residents, neighbors, and guests, childcare providers might also consider limiting time with the children in that area, especially if law enforcement has been reportedly seen or, suspected to be seen around the community. And it should be noted that field trips and day trips are another kind of part of someone's childcare program policy that should be in place. It's taking people outside of a childcare facility that might have, more protections in terms of private spaces and who can actually enter those spaces. Field trips and day trips are likely going to be in public places where law enforcement might be coming up and actually questioning or trying to engage with a childcare provider and children in care. So, of course, people still have these rights in public places, but absolutely a plan should be in place for the childcare program on how adults present are going to engage with law enforcement in protection of the children in their care. And of course, because we've been seeing just a variety of heightened interactions with law enforcement and children, it's important to consider possibly temporarily limiting or canceling field trips and day trips in public places with children in the childcare program. And it's also important to note that some childcare programs do engage in pickup and drop off of the children in their care. So they're driving the children in their program to and from their homes. And again, all that to say that they might see an increase in law enforcement interaction on the road with like checkpoints and things like that. But they do still have the right to remain silent, the right not to answer any questions about their immigration status, things like that. Drivers in general can refuse to consent to law enforcement searching their car, but it's good to note that law enforcement, if they do believe that there's an evidence of a crime in someone's car, they can proceed with the search without needing consent. Passengers in general can ask officers or agents if they are free to leave the vehicle if a vehicle is stopped. And if they are allowed to leave and they aren't being questioned, they may obviously leave the scene, but this is going to look very different if we're talking about a childcare provider driving like a van full of children. We're not going to be encouraging any of the children to exit the vehicle alone, and this should definitely be discussed and outlined in a policy that a childcare provider program has when driving children in care. And of course, with that being said, with anyone living in California, it's really important to note the general, pretty broad 100-mile rule or 100-mile zone where U.S. Customs and Border Patrol, also known as CBP, can conduct searches without a warrant of any area within the 100-mile zone of a US border with another country or 100 miles from the border with international waters, or for us, the Pacific Ocean. This 100-mile zone in California does cover much of the state, so it is important to, notify people that they might see more interactions with CBP, even away from the US border with Mexico. But even with that being said, people still have rights and they are still not allowed to be subjected to unreasonable searches or seizures, even though these things do happen. It's important to prepare people for this chance and to inform people that they still have rights, even when stopped in a vehicle or stopped on the street. Now, we also want to note that when discussing childcare programs, we should also be discussing employment-related interactions with immigration enforcement, including, considering there might be an I-9 audit of a childcare program or an I-9 raid of a childcare program. And that, of course, it is required for childcare employers to ensure that childcare workers do have I-9 documentation on file to prepare for these types of interactions. But in general, employees do have the right to stay silent and to ask for a lawyer during any interactions with law enforcement in the workplace. And generally, employers should have employees' contact information, emergency contact information on file beforehand, just to ensure that if there's an incident in the workplace, an employee is detained or questioned by law enforcement, that employers can get in contact with their family, friend, or lawyer if needed. Employers should advise workers not to talk to law enforcement without a lawyer. They should absolutely not compel or demand that they talk to law enforcement if they do not choose to do so. They should not require workers to provide identification or other documents to law enforcement. They should not help law enforcement identify people by immigration status or citizenship status. And if law enforcement enters a public area of the business, employers should prepare to say that they're the employer, that they cannot go to other areas of the workplace without their permission. And again, if law enforcement tries to enter a private area, employers should be prepared to demand a valid judicial warrant for them to proceed. And if employers feel safe enough to do so, maybe themselves or the authorized contact person should be the one ensuring there's documentation or recording of the encounter with law enforcement, which could include saving any surveillance footage, security camera footage taken during the interaction, audit, or raid. Now, the next slides are kind of just reminders of what we all just went over, but I do just want to note a couple of general things that I didn't really touch on before. And that's, thinking about what adults and advising adults to say if they are fearing for the safety of children that they are around or taking care of during a law enforcement interaction. And that's saying something to the effect of, I do not consent to law enforcement speaking with children. It is in the best interest of children's health and safety to direct questions to me, the adult, or the other adults present, and the adult's lawyers. And of course, ensuring that you're asking for a valid judicial warrant whenever you're being approached by law enforcement in a space that is not open to the public. And with that being said, if a adult is taking care of children in a space they're being engaged with by law enforcement and there's another adult present, those adults are allowed to say, hey, one of us is going to have a policy where we take the children to a separate place and the other adult is going to only engage with law enforcement. You do not have to subject the children to remain with you and go through questioning with law enforcement. You can ensure that they are separated in a different location so that you can engage with law enforcement without them being exposed to that interaction. And again, here's just some like reminders, a summary of what I just talked about in employment related interactions, asking for a warrant or a subpoena, asking about the purpose of law enforcement coming into a childcare program for an employment reason like an audit or a raid, things like that, and ensuring workers' rights are protected, and then an employer is not like demanding that anyone just give over documentation or just openly talk to law enforcement. Similar with the slide that I talked about in terms of field trips and daily outings, it's really important to note that now non-citizens over 18 must carry proof of immigration registration at all times. Do not ever show law enforcement false documentation, and people still have the right to remain silent or ask to talk to a lawyer before answering questions, even when interacting with law enforcement in a public place. Yeah, and similar to my slide about transporting children in childcare, everyone in the vehicle, no matter citizenship or immigration status, have the right to remain silent and to not answer questions from law enforcement without a lawyer. And I do just want to briefly end on these last two slides that with preparation and actually engaging with law enforcement in and around childcare settings, it's really important to end an interaction with checking in with the people that have been going through it. And that's contacting families and talking with children in care, really ensuring that the children are okay, have a place to talk about their feelings and discuss the incident, ideally with a professional counselor or social worker. And of course, documenting and telling families what exactly happened, what requests were made by law enforcement, any law enforcement interactions with children or staff, and how the child care program implemented their policy and protected children and families' private information. And of course, this goes without saying, but talk and support workers at the child care program. Provide a space to discuss things like collective grief and fatigue. Encourage time for self care and self compassion. Just things that any workplace should be doing anytime there's an interaction with law enforcement. Like with families, share immigrant rights information and mental health resources with workers. Contact their union. Offer leave while affected workers apply for work authorization. If we're talking about them being wrapped up in an I-9 audit or in an I-9 raid, ensuring that you're paying any owed wages and benefits promptly, things like that. And of course, if someone is arrested or detained, really key to contact that person's family with any information about the arrests and to contact an immigration attorney to understand the program's rights after the arrest and whether the person arrested needs to be connected with an immigration defense attorney. Okay, so that concludes today's training. I did just